Hello everyone, and welcome to today's webinar on approaches to promoting more efficient and effective restructuring regime. I would like to thank you all for taking the time to join us today. Before we get started, I'd like to thank our partners, CLDB, INSOL International, and the World Bank for helping us to put this program together. I'd like also to welcome our speakers today, Judge Thomas, Mr. Patrick Potter, Mr. Simon Charlton, Mr. Andre Martinez. They are leading experts in the field of bankruptcy, and we are very happy to have them with us today. I will leave the introduction of the panelists to Mr. Andre, who is the moderator and the panel chair for today's webinar. Mr. Martinez is a senior financial sector specialist with the World Bank's insolvency and debt resolution team in the finance, competitiveness, and innovation and global practice. Andre has been a lawyer for over 20 years. For over 12 years, Andre has been advising countries from Latin America, Middle East, Europe, and Asia on legal reforms with focus on debt recovery, insolvency laws, and workout mechanisms. Actually, Mr. Martinez is not strange from Saudi bankruptcy law. He has spoken on a number of occasions to audiences in Saudi Arabia, including the first conference on bankruptcies held in April, I think, 2019 in Riyadh here, and worked and his team in several insolvency matters. I will leave you now with Mr. Martinez. Mr. Martinez, please, the mic is yours.
Thank you so much, Dr. Abdullah. It is absolutely fantastic to be back in Riyadh, even if virtually this time. I very much welcome the collaboration that we have with INSOL International, with the Commercial Law Department Program of the United States, and of course with the Bankruptcy Commission that I had the very big honor to see when it was about to be created back in 2015, when I was for the first time in Riyadh. 2015, 2016, there were discussions about the creation of the Bankruptcy Commission, and I was very lucky to participate and be there and collaborate with the absolutely incredible progress that the Kingdom of Saudi Arabia has made in the bankruptcy system, going from a very antiquated system back in before 2016, before the passage of the new bankruptcy law, to what today is a very sophisticated system. So it's a great honor, and I think the topic is extremely relevant, because at the World Bank we have seen many laws being passed, and then they need to be implemented, and there's always a long road to go. This is why when we were discussing with Dr. Abdullah and the Bankruptcy Commission, we concluded that looking at the experiences of both the United States, that has a very long-standing tradition of using their insolvency system, and also top restructuring experts that are today active in Saudi, could be a great combination to try to build that bridge of implementing the law. And this is what today's panel is all about. Is about trying to understand how there can be an effective and efficient restructuring system in place, and what characteristics it has, and what's the road ahead, right? So those are some of the topics that we'll be discussing today. And for that, we have an absolutely outstanding panel, and I will now start introducing the panelists. But before I do that, let me just say that INSOL International will also be running a seminar in Riyadh on January 22nd next year. So they have been working closely with the Bankruptcy Commission on this, and this is just a shout out for something in the future. So let me introduce the panelists for today. Judge Thomas Cagliora, was appointed a U.S. bankruptcy judge for the District of Maryland in 2006. He has served as chief judge of the court between 2019 and 2022, and then moved to recall status earlier this year. Prior to his appointment, or later this year, actually, in October 2023. Prior to his appointment as judge, Thomas Cagliora was a partner in the law firm of Pillsbury, Winthrop, Shaw and Pittman, in Washington, D.C. And there he chaired the bankruptcy and insolvency practice for 7 years. His practice addressed all aspects of insolvency law, including representation of debtors, creditors, creditors committees in bankruptcy courts across the country. Until 2018, Judge Cagliora served as a chair and the 4th Circuit representative of the Bankruptcy Judges Advisory Group, which advises the Director of the Administrative Office of the United States Courts on matters pertaining to the operation of the bankruptcy court system. He is a regular speaker and instructor at bankruptcy seminars and conferences. And very importantly, Judge Cagliora has also been very active internationally and also in the Middle East as well, including Saudi Arabia. Patrick Potter is second panelist, and Patrick Potter is a practicing lawyer in the insolvency and restructuring group at the international law firm of Pillsbury Winthrop. He's a resident in the Washington, D.C. office. He has been practicing in the corporate Chapter 11 space, representing debtors, creditors, creditor committees, and other constituents for approximately 35 years. Over his career, he has appeared before roughly 50 bankruptcy judges nationally. His clients are involved in a broad range of industries, including commercial real estate, construction, healthcare, hospitality, and energy. He has worked on capacity building in the Middle East and North Africa region, including statute and rule drafting and implementation since 2014, which is actually when we met, Patrick, if I'm not mistaken. He has worked on approximately 20 programs like this one and other projects with the Saudi insolvency policymakers and professionals in and outside of Riyadh. He was also, by the way, speaker in the first bankruptcy conference in 2019. So that's Patrick is definitely not a newcomer to the Saudi Arabia legislation. And last but not least, Mr. Simon Charlton. He has been 25 years. He was 25 years with Deloitte and involved in restructuring work in multiple jurisdictions, including being based in Washington, D.C. For quite a few years. His first experience in the Gulf, including Saudi Arabia, was back in the 90s. Since then, of course, much has changed in the region. And for the past 10 years, Simon has been the debtor-appointed CRO for Ahmad Hamad Al-Ghosaivi, and saw them file for a restructuring procedure under the relatively new Saudi bankruptcy law. Currently, Simon is working with the company, the creditors, and the court-appointed bankruptcy trustee, overseeing the implementation of the plan. So we are in company of an absolutely fantastic panel, and I think the combination of skills of both Judge Cagliora and Patrick, with a very heavy U.S. law knowledge, and Simon, who has been active in Saudi Arabia market for so many years as chief restructuring officer for such a large case. The combination of these can only be a very enriching experience. So let me, with those introductions, let me kick off. I would like to ask Judge Cagliora first. What are, in your view, some of the main factors contributing to an effective and efficient restructuring in the U.S.? Judge Cagliora, the word is yours.
Thank you very much, Andres. It is indeed my privilege to be here today, participating in this program. Excuse me. I always enjoy discussing the U.S. restructuring system, what we think is good and what we think can be improved. And I always enjoy hearing about others from their restructuring system, what they think is good and what they think can be improved. Obviously, all of these systems are evolving, and the objective of all of these systems is to help businesses restructure in an efficient and effective way. The U.S. system, like most, if not all, restructuring system, is based on the premise that we believe capturing going concern value can maximize recoveries to all constituents as opposed to liquidation. Going concern value is captured in one of two ways. One is through a sale of the business as a going concern in a bankruptcy case under court supervision with the rights of creditors to object. The other is reorganizing a debtor and restructuring a debtor through a plan of reorganization under our bankruptcy code. Our code addresses both going concern sales post-petition, post-filings, and restructuring debtors through a plan of reorganization. And today we're going to focus primarily on the latter, restructuring a debtor through a plan of reorganization in what we refer to as Chapter 11. Obviously, there's a lot of benefits to a successful restructuring system. For one, it preserves jobs if you can preserve a going concern of an enterprise. But creditors and investors are more willing to lend and invest if they know that their claims and interests will be properly and fairly handled if the debtor suffers some financial distress. And that's the hallmark of our system. They know that whatever recovery they get, it should be maximized through the use of our system. It's a very, very brief summary of our system. Perhaps you know that a debtor files a Chapter 11 petition, an automatic stay applies, all actions must cease against the debtor. The debtor is given a breathing room period of time to perhaps modify its business, eliminate burdensome contracts, decide what its business plan is best going forward, and leading to a plan of reorganization. That period of time during up to the time that the plan is filed, the debtor operates under court supervision, and any actions outside the ordinary course must be approved by the court with notice to creditors. Our code provides the rules and requirements both for that period of time after the petition is filed, and of course also for how the plan of reorganization is proposed and voted on and agreed to. There are any number of important characteristics, as Andres asked, about what I think are the most important characteristics of a successful system. And there are so many to discuss in a brief period of time, but by way of an introduction, I would address some broader concepts that I think are very critical. The first is transparency and full disclosure. Transparency and full disclosure has both a substantive and a procedural importance to a case, as I put it. Substantively, all parties must know the activities of the debtor, the assets of the debtor, whether assets were transferred pre-petition, what the business plan of the debtor is. They must know this in order to make informed decisions along the way of the debtor at any point in the case. And of course, importantly, ultimately leading to reorganization. Is this debtor a successful candidate for a reorganization? Is a reorganization viable? So the substantive knowledge that is given through the process is critical. Transparency and disclosure is important, as I would put it, procedurally. I can't imagine a restructuring system where creditors believe that there may be assets they don't know about, assets that were transferred pre-petition, or that decisions are being made behind closed doors or in secret and not in the open forum. And so in order to have creditor confidence, you must have transparency and full disclosure. Another important topic and characteristic is predictability. Creditors and debtors and parties in interest must know the rules and procedures that a court is going to apply to any given problem, including ultimately reorganization and a plan of reorganization. It doesn't mean that every outcome is predictable, because after all, each case is different as a matter of fact. But it does mean that the creditors, the individual creditors and parties in interest must know what rules and procedures will be applied to solve that problem. That way they can assess the issue themselves. They can come up with what they believe will be the range of recoveries. And frankly, that leads to an awful lot of settled resolution because the parties can come up with a range of recoveries and discuss between themselves how they should resolve it. So it's important for judges to disclose the rules and procedures they follow when making any determination. An additional important characteristic is the balancing the rights of a debtor for a fresh start with the rights of creditors to be paid. That pendulum can't swing too far in one direction or the other. We'll be talking about creditors' rights, I expect, later today, but creditors must have the right to information, as I described, the right to participate, the right to make a meaningful vote, the right to have the priority and collateral positions protected in a fair and equitable way, and the right to assert their claims, among other rights. And finally, all these matters must be administered by a fair and impartial judge who has specialized knowledge in this and can make sure that all of these rules and procedures and issues are properly presented to all parties, and a fair decision is made that parties understand whether they agree with it or not. So those are some of the more important characteristics, I think, in a reorganization proceeding. And I'm sure we'll be discussing some of those and others in the rest of the program. And thank you very much for the opportunity to appear today. Thank you.
Thanks so much, Judge Cagliora. This is such a great introduction. I mean, the emphasis on the importance of transparency, of predictability of rules to be applied, the creditor's rights and the fresh start, and the institutional aspects like super specialized bankruptcy judges. Those topics are really some of the key that immediately come to mind when talking about the efficient and effective restructuring system. Patrick, do you have anything to add to this? I'm sure that with your view, with your lens as a very experienced practitioner, you have quite a few other topics to add.
Yes, good morning, everyone from Washington, D.C. Good afternoon in Riyadh and in other locations. First of all, very quickly, I want to thank the partners and sponsors, the World Bank, of course, the Bankruptcy Commission, Insel International. I want to thank Susanna Thompson and Vanessa Evans for their hard work putting this together, and co-panelists as well, Abdullah, and thank you, Andres, for your kind introduction. As Judge Cagliota said, there are many characteristics of the U.S. bankruptcy system, some good and some maybe not so good, that result in efficient and effective restructuring, reorganization. And let me just preface my comments by saying that in the U.S. Bankruptcy Code, we have a relatively new provision from 2020 called Subchapter 5. I'm not going to talk about Subchapter 5 right now, and we may or may not have time to talk a little bit about it towards the end of today. What I'm about to say really is outside of the scope of Subchapter 5, particularly on the first of sort of 2.5 topics that I want to cover very briefly as an introduction. And that's the topic of eligibility to file for Chapter 11, which is, I think, the primary focus of today's presentation, as opposed to other chapters in the Bankruptcy Code providing for other forms of relief, including liquidation. And when it comes to eligibility for traditional Chapter 11 debtors, we in the United States really don't have a burdensome list of eligibility requirements. Again, different for Subchapter 5, Chapter 11. And in particular, we don't have a requirement that the debtor be insolvent, whether it's a balance sheet insolvency test or some other form of insolvency. There are a number of ways that we in our field look at whether a debtor is insolvent. It's absolutely not a requirement. A debtor can be, in fact, solvent and is still eligible for Chapter 11. I've represented solvent Chapter 11 debtors in order to avail itself of provisions in the Bankruptcy Code. The only real test that we have for eligibility is good faith. We've made the policy decision that fighting over whether a debtor should, litigating, I should say, over whether a debtor should or should not be in Chapter 11 is really not the best use of the scarce resources that are as prevalent in all cases. And so we've made that policy decision, and we put more pressure on the debtor to act in good faith and to proceed expeditiously and to get on with its Chapter 11 process, start negotiating with creditors and heading towards the exit of Chapter 11 rather than creating barriers to entry Chapter 11. I think that's one of the hallmarks of our system that makes it work effectively and less expensively, at least on that topic of eligibility. The other point that I wanted to make is around, and particularly from the lens of a practitioner, which is what I am, and that's the use of Chapter 11. And the way I practice, and the reason why I think it's effective, at least when I'm in the cases that I'm working on, is because I don't file bankruptcy cases just to file a bankruptcy case for a client. I don't file for purposes of creating or obtaining delay in of itself. That rarely works as a strategy, just to go into bankruptcy and to sit around for an extended period of time. Usually creditors, the U.S. Trustee's Office, which is a division of the Justice Department, and the judges will not allow a debtor to languish in a Chapter 11 case. And so the best approach, and I think the most effective approach that most of us take, is to have a plan. And Judge Catliotta discussed two types of strategies: sales strategy, restructuring strategy. This is something that my client and I, when I represent a debtor going into bankruptcy, is of paramount importance, is to come before the judge with all of our documents in order, with a narrative about what the problem, the financial problem and its causes were, and then what is our strategy? What do we hope to accomplish? And we should be in a position on the very first day of the bankruptcy case to tell the judge, this is what we want to do. We want to conduct a sale. Hopefully we have a buyer lined up. We want to go through a restructuring process. And we try to give the judge a calendar. It's not going to be a perfect calendar, but we're going to try and do this in 90 days. We're going to try to do this in 120 days. And then we meet with the court, we meet with the parties, and we map out a series of hearings and try to get through the case as quickly as we can. You've heard it before from me and from others. You'll hear it again. Time is not your friend in a Chapter 11 process, mostly because of the cost and the distraction from your underlying business. So the best thing, I think, that what makes our system work effectively is that we're expected to show up ready to go. Just a final point, I'll wrap up, Andres, and that's just to emphasize that which Judge Catliotta said, and Andres as well, and that's transparency. I cannot emphasize that concept. Judge Catliotta described it from the debtor's perspective, being transparent about your assets, liabilities, and transactions. But transparency pervades every aspect of bankruptcy, including lawyers who represent estate interests. We're required to disclose all of our contacts with anyone in the case. Judges themselves engage in transparency. Creditors have some transparency obligations. The notion of the opposite of transparency and confidentiality is not the rule of the day. And it is, in my view, I actually think it's the most important policy driver in U.S. Bankruptcy law. And I think it's one that should be driving successful bankruptcy regimes elsewhere. With that, I'll stop.
Thanks, Patrick. And indeed, yes, transparency cannot be overly emphasized. I think in this also Saudi Arabia has made quite a bit of progress with the Bankruptcy Commission being publishing so much information nowadays in the website too. Let me move on to Simon, and I think Simon, I mean, you've been active in restructurings all over the world, including in my wonderful city of Buenos Aires, by the way. So why don't you just tell us a little bit about your role as a chief restructuring officer in this pretty large case in Al Qasaibi, of course. And again, the question for you is the same. It's the icebreaker question, kind of open-ended. How do you see, what are your views on how to achieve a successful restructuring in general in the system of the new law of Saudi Arabia? Simon.
Andres, thank you. And I'd just like to also thank INSOL, the World Bank, and clearly the Bankruptcy Commission in Saudi Arabia, who I've come to know very well. I think great strides have been made over the period that I've been involved in the kingdom, and I'd like to thank everybody for that. It's a real pleasure to join this call and to hopefully share some of the experiences, good and bad. Sometimes we learn more from bad things and failure than we do from the good things. I mean, I would second everything that the judge and Patrick said. All the things that they said are equally relevant in Saudi. I think the points that I would stress are early engagement. And I think we've seen a cultural shift in Saudi Arabia and across the Middle East. Bankruptcy used to be a dirty word. Nobody ever wanted to face up to it or deal with it. And I think now we're seeing people recognizing that actually restructuring is a viable tool for companies. I think, creditors are much happier to invest, to advance loans in a country if they know that there is an exit strategy if things go wrong. So I think for the kingdom, it's important. I think for creditors, it's important. And for debtors, it's a useful tool. Just a little bit on my background. I was with Deloitte for 25 years, became the chief restructuring officer of what we refer to as AHAB, Ahmed Hamid Al-Ghasabi and Brothers, in 2013, when there was no bankruptcy law. So people often ask me, you were the chief restructuring officer, what were you trying to do? We were somewhat in a vacuum. And I can honestly say, without the bankruptcy law, this would have been a continuing disaster for a very long time. You needed unanimous 100% support of every creditor. There was no restructuring regime. It was sort of a first come, first serve to the enforcement court. So it was, I think, very damaging to creditors, very damaging to the company, and there was no real path forward for us at AHAB. I think it's interesting, and I mentioned before the cultural shift, the fact that the company took a decision without the framework of a law to appoint a CRO. And I think on our side, that was really important because there had been a significant breakdown in sort of trust between lenders and the debtor, and having somebody focused on trying to achieve a settlement, I think was important for both sides. Very often if you're managing a business, particularly one that's in distress, that is more than a full-time job. So having somebody else whose focus is to perhaps try to find a solution. So I think that was important. So that was somewhat unique. I wasn't appointed by creditors, I was appointed by the debtor. And we filed in late 2018. We were admitted into a restructuring procedure, what we refer to as an FRP, in May of 2019. We presented a plan to creditors. We worked extremely closely with the trustee, and I think that's one of the things I would highlight. Getting yourself a good trustee, one that knows what he's doing and one that you're able to work with, is really important. So pre-filing the proposal, the trustee has to review the proposal. He's going to be involved in supervising the business. He's going to have to produce an inventory of assets. And on that, to the point that Patrick was making and the judge, don't lie. If you start doing that from the beginning, you're in big trouble. So it's sometimes not intuitive, but you have to tell the truth. You've got to put everything out there. The trustee will produce an inventory of assets to the court. We then presented a proposal in September of 22, and that was voted on, and 96% of our creditors by value supported. The court then ratified that proposal, and we're now going through the process of implementing the terms of that proposal. We've made 2 distributions to creditors, so we've now distributed 17% return to creditors, and virtually everything we've done has been novel and new because the law is so new. So we're now in the process of dealing with a large real estate portfolio and working with all the authorities in Saudi Arabia. So that's what we've done. I think the things I would highlight are engage early, don't leave it until it's too late. You know, if you want to do a restructuring, the sooner you engage, the better. Before you file the application, try to find yourself a trustee. There are plenty in the kingdom now, and thanks to the Bankruptcy Commission and others, they are becoming very quickly very experienced. So find somebody you can work with. At the end of the day, if you can't work with the trustee, it's going to be a problematic experience. Engage with creditors. So early engagement, go in with a plan. I think Patrick and the judge mentioned that. You know, don't just rock up at court and say, we want to file for a restructuring, because the judge is going to say, tell me how that's going to work. You need to have a plan. The plan may change, but have a plan. So be prepared, plan, early engagement, and absolutely critical is communication with all your stakeholders, whether it's Bankruptcy Commission, the court, creditors, employees. You need a comprehensive plan as to how you're going to communicate. And I think one thing that I think is often forgotten, if you're filing for a restructuring, yes, you're seeking to settle with your creditors, but you have to be able to present to the court a viable restructuring. And very often I see situations where everybody's focused on, let's do a deal with the creditors, and they forget the latter bit. And I have seen instances where people have gone to the judge and said, yes, we'd like to do a restructuring. Here's how we propose to deal with creditors. And the judge said, well, what's the restructuring plan? If you don't have one, the judge may say, well, then you should be in a liquidation. So be prepared, plan, communicate, and engage early. I would say my key takeaways.
Thanks, Simon. It is fascinating to see that how that law that was still, you know, on paper and nothing else back in 2016, 2017, all of a sudden becomes so important. You just emphasized the importance of the bankruptcy law for your process, right?
Well, we would not, you know, without the ability to get cram down, cross creditor class cram down, it would have been impossible. And I mean, I lobbied certain elements of the government, and they would say, what do you need to resolve this problem? And I said, we need a framework, we need a law. And, you know, I can remember reading the World Bank report where, you know, it was rated highly because they'd introduced the law. And I always said to people, the key will be, does it work? You can have a good law on paper, but does it work? And I think massive credit to, you know, the Bankruptcy Commission, the Ministry of Commerce, and the professionals on the ground, whether it be the judges, the practitioners, the lawyers, the accountants, because they have worked really hard and really fast. And I think if you look at our case, we filed in May 19. We then had COVID, right, which pretty much stopped everything. And yet by September 22, you know, we had 96% of creditor support, ratification by the court. And within 6 months of that, we'd made distributions to creditors. Prior to that, we had almost 10 years of nothing but destructive litigation. And it was destructive to creditors, it was destructive to the company, the owners, the employees, and I think even to the Kingdom of Saudi Arabia. So I think, you know, our case shows that there is a law, the law works, and it's not necessarily slow. I think if you take out COVID, we probably lost a year to COVID in our process.
Thanks, Simon. Yeah, indeed. And I like the fact that you emphasize the importance on cram down, because I was going to ask Judge Cagliora precisely about creditors and rights and protections. And I think that's while clearly in the bankruptcy law is so important to have you know, some sort of way to impose it to minority or dissenting creditors, still need to ensure the right balance is there. And I'm sure as a judge, that must have taken quite a bit of your time. I am wondering what are your views on protecting creditors' rights and in general the balance between creditors and debtors' rights in the US system?
Yes, as I mentioned, the system sort of balances the opportunity of a debtor to restructure with the rights of creditors to be paid. And that's sort of a balancing that is within the law and within the process of the bankruptcy restructuring system. Creditors must be given some basic fundamental rights during this process for it to work. As I mentioned before, the right to participate during the case when a court is being called to make any decision if a debtor seeks to do something outside the ordinary course, and of course on the plan of organization itself. Simon made a very important point that I sort of alluded to, which is that the plan must be feasible. A debtor can agree to pay anybody anything, but if the prospects of the business are such that that's not a feasible plan, the plan is not going to be approved. And so the creditors must have the right to participate in that process, the right to be heard during the case. They must have the right to obtain the information and make their own decision about whether a decision is going to be made, about whether the decision should be made. And then in the actual approval of the plan itself, the creditors are given some choices. First of all, they have to be placed in a similar class so that they have a meaningful vote. And they vote for or against the plan of reorganization. And that voting is by class, so that their vote matters, but their vote may not control a class. Sometimes the creditor's vote does control a class if the claim is so large. It's a 50% of number and 2/3 of amount is the usual formula for approving a class. And sometimes the creditor has a very small claim, and sometimes the creditor controls the class. And so in the event that the class approves the plan, and the event that there are sufficient votes in favor of the plan, a creditor who doesn't support a plan can still take action to seek to defeat the confirmation of the plan. And we refer to the same term that Simon used, which is cram down. And that term means a debtor will seek to confirm a plan over the objection of a creditor or an objecting class. And our code provides various formulas and requirements that the court must consider in terms of whether or not cram down should be approved. But the creditors have the right to pursue that. They have the right to object. Many cases, in fact, I would say most cases, do end up with a consensual resolution. And that's because, as I said before, if the rules and procedures are known to the parties, they can make their own assessment as to whether they think what the outcomes will be, and then they can negotiate within that range of outcomes for a suitable arrangement. But yes, creditors indeed do have the right to participate and to defend against the cram down.
Thanks, Judge Caldeora. Yeah, indeed, classification of creditors is clearly an issue. I mean, in many countries it's being discussed, particularly those that are currently drafting the law, and it links very much with making sure that a secure creditor, for example, is not impose a plan by unsecured purely, right? And that I'm sure that it's a topic that is very close to everyone's hearts, because my understanding of the Saudi Arabia law is that it also contemplates a more or less a clear classification of creditors, right? So that's very important.
I should follow up, Andres, if I may quickly.
Please,
you make
please,
a very
Judge.
good point, which is that the rules and procedures apply differently to unsecured creditors, to priority creditors, and to secured creditors. Secured creditors do have the right to obtain protection of their collateral position. And in order to cram down a plan on a secured creditor, the debtor must prove that that secured creditor is going to get the value of its collateral, not necessarily at the time of confirmation, but over the period of the plan. Whereas the rules for what an unsecured creditor should get to cram down a plan on an unsecured creditor are much less. They are basically that the unsecured creditor must get at least what that creditor would get in a liquidation, and that creditor has the right to, to vote and participate. So the rules are different based on the different classes of creditors under the plan.
Thanks, Judge. That's excellent. That's a great clarification.
And Andres, if I could just
Please,
make
Simon.
a comment on classification, I think for the trustee, I think that's probably one of the more challenging aspects of their job, particularly with a new law and very little precedent, and perhaps they've not been involved in that kind of procedure before, because the trustee has to review claims and make recommendations to the court as to which claims should be accepted and which claims should be rejected. And that doesn't necessarily mean, I think in the old days, you had to have a judgment, you had to go to the enforcement court, get an enforcement order. The bankruptcy law doesn't require you to have gone to judgment. You can still have a valid claim. So I think for trustees in the kingdom, particularly in the early days, that's probably one of the harder tasks that they have to do, is reviewing claims, which claims should be accepted, which should be rejected, and then putting them into classes. And the law does require you to put them into different classes.
And Simon, can I follow up with a question here? I think it's always very, very sensitive, the classification of creditors, at least in most of the jurisdictions that I've worked. And in Saudi, the classification is proposed by the trustee himself or herself, or is it proposed by the debtor?
The way we did it on ours was we worked with the trustee, and I think we've been incredibly lucky because we've had a good relationship with our trustee, and we've been able to work together. I think if you don't have that relationship, particularly in a restructuring, obviously in a liquidation, it's different. The liquidator has one job and you're not really perhaps that interested in the debtor, but we're effectively a debtor in possession. So we're still trying to manage our business. We're trying to present a plan for the settlement of claims. How do you deal with the different claims, different classes of claims? You sometimes see a little bit of, let's call it engineering, the requirements for, if you've got multiple classes, what the voting thresholds are. So sometimes you'll see people trying to perhaps be a little bit clever. But again, I think transparency and honesty is absolutely critical. We didn't have secured creditors, and luckily we didn't have employee claims, because obviously if you get into a very complex situation where you have employee claims, governmental claims, tax authorities, secured claims, unsecured, it does become quite challenging. I think the other point I would make, in a Sharia law country, cram down is quite a big deal, because my understanding is under Sharia, you cannot unilaterally extinguish another party's claim. So I think for Saudi Arabia to have adopted cross-class cram down was really quite a significant move on their part, but one that's absolutely critical to our success and the success of the law.
Andres, if I may,
please go ahead.
We have a term for what Simon characterized as the creative use of classes to try to work yourself up to an accepting plan. And the term we use is gerrymandering. And gerrymandering comes from our political system, where you try to manufacture voting districts to get elected. And so we say that a debtor or plan proponent has gerrymandered a class, and the courts are very wary of that.
Thanks, Judge Callejon, and thank you so much, Simon, for these clarifications on the practice of the Saudi system. I think classification of creditors and recognizing adequately that process of admitting creditors is indeed one of the key aspects of the bankruptcy law. So Patrick, if you would like to add anything to this discussion, please feel free to. Also, I would like to really hear from you, Patrick, on the notions that particularly Simon touched upon, which is that there is still a perception of every time we discuss about bankruptcy law, the word fraud or stigma is floating around. And I've heard you many times explain very clearly how this shouldn't be the case, right? So I would really like to, particularly in the context of what you said before, right? So you mentioned at the beginning, you mentioned eligibility in Chapter 11, open, no requirement to insolvency. How do we make sure that there is no abuse of the system? And I would really like to hear from you on that.
Thank you, Andres. Let me just, before I answer the question, I'll do it rapidly given time constraints. I'm really thrilled to hear this war story and the descriptions from Simon. Folks, this is not the last you're going to hear from me on this. We need to be hearing more about what's going on in Saudi in the bankruptcy process, particularly for the conference that Andres mentioned in January. I think for those panels to work effectively, we need to do deeper dives and learn more about what's going on. I'm thrilled to hear what Simon said. What a great success story that is. Saudi should want to showcase that and replicate it at all levels where it's possible. So thank you, Simon. Maybe everyone on the audience has already heard Simon speak, but it's the first time we've worked together, and I'm thrilled to be hearing it. So this issue, you're right, Andres. We've done all these capacity building programs, and it's not unique to Saudi, and it's not rare in the United States. Creditors who you're suspicious of your borrower, they're not paying their debts, you don't know what's going on. You're supplying goods, you're supplying services, you're not getting paid. And I think this plays largely, and so you think the worst. You think that the debtor is and its principals are lining their own pockets. They're taking care of themselves and their family, and they're not thinking about their creditors. And I think this is one of the many policy reasons that drives the important discussion that we've already had, and probably we'll touch on again before we end, which is on the transparency. It touches upon the point that Simon made, which is communicate with your creditors early in the process before things get really bad. And often, and with all your constituents, don't leave anyone out, because those who don't know what's going on or are eventually going to presume the worst. That seems to be the apparent human nature. We're fortunate to have a very transparent process, which we've already emphasized, and so and we've got tools in our system, including the right to examine debtors, so that those who have suspicions and may have some element of proof can come before Judge Catliola and say, Judge, we think there's something amiss here. I will say, statistically, the number of bad actors, you have to define bad actors, and I don't think using the bankruptcy code is not a bad actor for legitimate purposes. A bad actor is someone's hiding assets, not being truthful, not being transparent, not following the rules. Those are relatively rare in our system, and we have a very, very large system. We're a big country, a lot of people, a lot of bankruptcies get filed, and they're relatively rare. But we've got tools for dealing with it. We have the right to take a quote unquote 2004 examination. We can take deposition. We can ask for documents. We can issue subpoenas. We can require the production of information and documents to test these concerns. And if they produce some fruit, then we can go to the judge and say, Judge, there's a bad actor here. They're taking advantage of the system. They're using company resources for their own good. They're harming creditors, and something needs to be done about it. And our law has a range of different things that can be done about it, including replacing the debtor and putting someone like Simon in place to run the company, to putting bad actors in jail. Again, I think it's relatively rare because of the emphasis the culture, the business and legal culture on transparency, but it does happen. And when it happens, it gets a lot of air in the press, and people know about it. And everyone involved is usually, sort of pushed out of the bankruptcy process. I think that's how we deal with it, notwithstanding the fact that it's not something that is rampant and prevalent in our system.
Thanks, Patrick. Thank you so much. Before I move on to the next question, which is I actually have a question for Simon, but before doing that, I would like to remind everyone that you can post questions in this little box that says Q&A. So you can post any questions. Could it be for any panelist in particular or all panelists? You're welcome to do so. We will go through one more round of questions that I will ask to the panelists, and then as questions start coming up, I will be asking the questions that are posted in the chat. Okay, so please, everyone can start asking questions at this point if they haven't done it already. Simon, this is, I mean, you're involved in a really large restructuring, and I was wondering now, one of the big developments in the kingdom has been the passage of the new cross-border rules. I've seen that, and I was wondering, have you had any relation, I mean, with the cross-border application? Have you encountered any issues before this regulation passed? What are your views on cross-border matters, if you had to experience any during your restructuring of Algo Saif Group?
Thank you, Andres. If I just make one quick comment on something Patrick said, I think it was really interesting. Patrick was referring to some of the tools that exist in the United States for bankruptcy trustees to obtain information. And I think not for today's call, but something that is definitely worth exploring in the future is the United States has a very well developed and very useful set of tools. And I think it's interesting for bankruptcy trustees in the kingdom to understand how they can use those, because quite often, particularly in the Middle East, obtaining information can be very difficult. So if you have suspicions or you have concerns, finding that information in the Middle East may be very difficult. But given that so many transactions are based in US dollars or electronic communications, I've seen reference to people using Facebook or Instagram or WhatsApp as sources of information. And there are some really powerful tools that I think exist in the US that could be used by bankruptcy trustees in the kingdom. So I think that's probably a whole separate topic for conversation, but something that, probably some of the people on this call would benefit from some more insight on. In terms of cross-border, we faced many issues before because you had creditors seeking to take action. And I don't criticize them for doing it. There was no bankruptcy regime, and obviously creditors were looking to recover amounts owed to them. So they would take action in different jurisdictions where Ahab at the time may have had assets. So we saw litigation in Tunisia, Jordan, Qatar, Kuwait, the UAE, Switzerland, London, the US, and Cayman. And we really struggled with how to deal with that. One, it's incredibly value destructive, I think, to everybody, unless you happen to be the one creditor who manages to secure an asset. What I have seen that I've been very pleased with is once we filed and we were admitted, there was a big question about, okay, you can get a moratorium in Saudi, but what does that mean in the UAE? So for example, one of our partners was resident in the UAE. how was there any protection available to her? And Ahab was an unlimited partnership. So ultimately, the partners had liability for the company. And actually, I was very pleasantly surprised to see that when we went to a court in the UAE, that they actually recognized the procedure in Saudi Arabia. Because if not, if a creditor can just go and pick another jurisdiction, it does devalue the process. So we've seen that, and that was helpful. We've seen it in other countries across the Middle East. We've not done anything outside in terms of Europe, North America, South America, Caribbean. We came a bit late for that, but I think that would be a really interesting area to explore. Cross-border cooperation, access to information, discovery, disclosure, and the like, I think is a really important, because you don't just want countries ring-fenced and then creditors able to cherry pick assets in other jurisdictions. So I think that's a really interesting area to explore.
Indeed, and another one where there's been clear progress lately. I think it's such a relevant topic. I'm glad that you pointed out the difficulties in obtaining information in general, right? That's one of the cross-cutting issues, and given that most of our audience is actually trustees, I think it is a relevant issue, right? The powers and that they have, and the recognition that they enjoy when it comes to seeking information that is relevant for the case is something that cannot be overemphasized. So that's something clearly a very important topic.
It's not intuitive. You wake up in Riyadh and you're dealing with a local bankruptcy. It's not immediately obvious to you that you should seek disclosure orders or information in another jurisdiction. But I think, the practitioners in Saudi Arabia are learning very quickly. There are some really good lawyers, there's some really good accountants, and people are learning really fast. But the US does have some really great tools, and other jurisdictions as well. So I think educating people as to what other sources there may be than the immediately obvious ones on your doorstep is important.
Thanks, Simon. Thanks. Just Leora, one of the topics that we haven't discussed today, and where the US is clearly at the very forefront, is the issue of how to ensure that those that provide fresh financing are also have a protection. And I think it's a topic that is where, if I'm not mistaken, the Saudi regulation has a whole chapter in the law about this topic, which is very similar to the US system in terms of granting protection to those that provide fresh financing. But at the same time, I think the US has such a developed system in terms of using it for so many years that has achieved certain predictability. And it's always worth explaining what it is about and why this protection exists for providers of fresh financing, and how to ensure that the rights of the other parties are also adequately protected. Right, so if you could please walk us a little bit through that system.
Sure. Starting from a little bit of a broader picture working in, one of the critical requirements of a restructuring case in the U.S. is that the debtor must be able to pay its post-petition expenses and obligations. And of course, those expenses and obligations increase dramatically because of the costs of professionals, restructuring people, attorneys, accountants, et cetera. If a debtor can't pay those costs and expenses, then it's likely a candidate for liquidation, and we wouldn't be talking about restructuring any further. So the debtor needs a source of funds post-petition, and the typical source of funds is the debtor's ongoing operations, including its receivable financing that it may have had pre-petition. And so it collects its receivables, and it can use those receivables because the collections of those receivables are the collateral of existing creditors. So the debtor can only use that collateral if the creditor agrees, or if the court determines that the creditor is adequately protected from the use of that collateral. Typically means that the debtor will collect receivables, use those funds to generate more receivables, which the lender will have a lien in, and then the lender is adequately protected by the increasing use of funds that thereafter create more and more receivables, so that the lender's collateral position improves, or at least doesn't deteriorate. Now, there are times, as Andres said, that the debtor needs more funds and than the existing lenders or its operations or even its investors will provide. Sometimes new funds are put in by investors. And we have a provision, what we call Section 364 of the Bankruptcy Code, that has various tiers of funding that can be applied post-petition. Essentially, the debtor must establish that it needs the money and the money can't be obtained through another source. And then there are certain protections, levels of protection that are given to creditors depending on the need for the funds and depending on the debtor's alternative approaches or alternative sources of financing. Some of those protections given to creditors include being given collateral on assets that don't have existing collateral, or being given collateral positions in assets that have senior collateral positions. In some situations, a court will allow a debtor to obtain money through this financing, in which the creditor gets a collateral position that is senior to existing creditors as of the case. So that if a lender has a collateral position in real estate, a court does have the authority to approve a loan to the debtor post-petition that will be senior to the collateral position of an existing lender. That's a due process issue because you are affecting the rights of a secured creditor, and that must be taken with care. And so the Bankruptcy Code does have protections that are given to the parties in that situation. It's available. The reason for it is because the funds needed during the case are often very important. Lenders would not make these advances in the absence of these protections. Lenders would not make these advances in the absence of a good price for these loans. So the DIP financiers, we call them DIP financiers, are priced very well, and they're very well protected. What often happens is that the existing creditors don't like to have another creditor come ahead of them, so that forces the existing creditors to come forward and advance new funds post-petition. So there's a sort of a choreography that exists between the existing lenders and the post-petition lenders. But that's an important source of financing for the larger cases, not for the smaller cases.
Thanks so much, Scaliora. Well, I am actually very happy and very impressed by the number of questions that are coming. And one of them is exactly a question that I was planning to ask Patrick anyways. So that is fantastic. Unfortunately, it says anonymous attendee, so I don't know who asked it. But someone asked about the difference between subchapter 5 and chapter 11 in the US, which is, I mean, exactly the question that I was planning to ask you, Patrick. How does the US now started dealing with small enterprises? And please, the floor is yours.
Thank you, Andres. So subchapter 5 is it's still chapter 11. It's a provision that's relatively new to the code, and as Andres knows, unfortunately, I can talk too long about this topic. I just spoke about it recently in Cairo, and I'm going to try to do it. Give you the cliff notes, the Reader's Digest, the smaller version. It is a provision that actually implicates this policy decision that we were talking about before around the balancing of rights between creditors and debtors, and subchapter 5 has taken that balance and radically changed it by doing a couple of things. One is, and maybe more than a couple of things, but I'll focus on two. One is that a trustee is appointed in all subchapter 5 cases. That's not the case in regular chapter 11. Relatively rarely are trustees appointed. And as a chapter 11 debtor's lawyer, I don't want a trustee in my case. They usually cause problems for my clients. And so the role of a subchapter 5 Chapter 11 trustee is actually not to run the company. It's not to do what Simon does as a CRO. In fact, it's to come in and facilitate and mediate disputes between creditors and the debtor. The other radical thing that subchapter 5 has done is to basically eliminate the effect of voting, and it enables the debtor to actually confirm a plan on paper, in theory, if every single creditor voted against the plan. The creditors would still have the right to come in and argue to the judge that the debtor doesn't satisfy other conditions to confirming a plan, but it wouldn't be able to come, the creditors wouldn't be able to come in and say, you don't have enough votes to confirm your plan. That's a pretty radical change in the law. So that leads to two final points quickly. And I would like to have Judge, if with your permission, Andres, Judge Catliotta, add any additional comment, because it's a very important topic. One is eligibility. What debtors are eligible for subchapter 5? Number one, there's a debt. It's driven by debt limits, and we say that the debtor has to have no more than $7.5 million of, I'll call clean debt, meaning it's not disputed, it's not contingent, it's not unliquidated. And it also has to be with third parties. For eligibility, we don't look at intercompany related party debt. So if you have $7.5 million in clean debt or less, then you're eligible. You also have to be engaged in some modicum amount of business. There's a lot of these panels that we're doing right now on subchapter 5. They're almost daily. There's one of these going on, and these are the topics that are really discussed a lot, which is the debt limit, what should be included, what should not be included, and the notion that you have to be engaged in some kind of business. Question should be from the audience, well, how's this working out? It's been around since 2020, and it's actually working out quite well. The success rate of getting to confirmation and confirming a plan of small businesses, meaning in this range of $7.5 million and less, was actually quite low before 2020, before subchapter 5. It's now, we think, hovering at least around the 45% success rate, maybe higher, a little bit early to tell if it's higher. The other thing is, you'd say, well, what about this nonsense of creditors' votes not mattering? That's just radical and just the opposite of everything we've always known about bankruptcy. And the reality is, at least anecdotally, what I'm hearing in all these panels that I listen to and what I'm seeing is that most cases are actually consensual plans between the creditors and the debtors, upwards of 80%. And it's really the rare debtor that actually has to go to the judge, and it's, I think, probably the rare judge that actually approves a plan where none of the creditors are voting for it. But this radical shift in policy has actually produced great results, and results that are consensual. Judge, I don't know if you'd had anything else to add to that.
Well, very briefly, I think it helps to discuss a little bit of background about why subchapter 5 came into existence. Most of us believe that the Chapter 11 process is a great process for mid-size and larger companies, but it was really failing the smaller companies, the really small companies, because it's so expensive, it's time consuming. Some of these companies have to hire professionals that they just can't afford. The creditors in some of these smaller cases weren't even particularly participating, so that these cases were kind of languishing and they were not being very successful. So that is why we created the subchapter 5 program, which Patrick said began in February 2020. Originally, the amount of the debt was 2.5 million. During COVID, it was increased to 7.5 million. And so that's a fairly sizable number. It is working. I agree with Patrick. It is working. These cases are being filed. One of the reasons why it works, to emphasize what Patrick is saying, is the role of the trustee. These are different case trustees than in our other cases. They don't have authority to act. They don't have authority to act on behalf of the creditor, or the debtor rather. But they serve a very important role of being a liaison between the debtor and the creditors, because after all, a lot of these creditors have fairly small claims in these cases. and they negotiate a plan, and they've been very successful in doing it. And so we're very pleased with the sub 5 process, and I think it's here to stay.
That is fabulous, and it's so much aligned with what we have been saying at the World Bank. I mean, we've done a lot of work around the micro and small enterprise insolvency since 2017, and we amended the World Bank principles in 2021, trying to encourage countries to have some specific rules for micro and small enterprises, which I know Saudi Arabia has, by the way, a lot of reductions in time and simplifications of process. Let me move on to the next question, which is for Simon. Simon, please, of course, feel free to add anything on this, but I think the question is, again, from anonymous attendee, who is very active today, is if today you started to restructure a company, would it be the same that was your job back in 2018, 2019, in terms of the know-how? The question asks about the judges, but also I will just ask you about the general culture that you referred to, the capacity of the different players that matter, including trustees. So could it be the same or could it be different, the landscape?
Well, when we first filed in 2018, we filed for a protective settlement procedure. That was rejected. Then we filed for a restructuring procedure, and that was rejected. Then creditors filed for a liquidation, and ultimately the judge put us into an FRP. So we kind of ended up where we did, which I think is the right place almost by default. And I think that probably says something about the speed at which the judiciary and the trustees and others have come to terms. Obviously, when we first started, nobody had done it. So there was some concern about what we should be doing. I think it also highlights what I think is one of the biggest challenges for the trustee, particularly in a restructuring procedure. Obviously, in a liquidation, the trustee really has one job: liquidate the assets and pay the creditors, and paramount in his responsibilities are the creditors. In a restructuring, I think one of the hard things for a trustee is balancing between the interests of creditors and the interests of the debtor. And I think somebody mentioned earlier, I don't know if it was the judge or Patrick, but quite often, you know, if creditors haven't been paid, understandably, they're upset. You know, why should a company be allowed to exist if they're not getting their money back? And I think culturally, that's an interesting point for the trustees in developing regimes where the law is new, for them to be able to deal with that. And I think luckily for us, many of the creditors, and I think again a sign of the development in the system is we're not dealing with the credit people at the bank anymore. We're dealing with restructuring people. And I think all of the banks in Saudi Arabia now have, whether it's special situations or workout or restructuring groups, and they tend to be a little bit less emotional about prior bad credits if you're dealing with the credit people. So I think that's been a cultural change that we've seen over the time. But I still think it's difficult for the trustees to balance that, because creditors, we just want our money. But obviously in a restructuring, an important part of that is ensuring the company continues to exist and is viable and safeguards employment and the like. And if I could make just one quick comment on what the Honourable Judge was saying before about DIP financing. And it took me a long time because people kept saying, have you tried DIP financing? And I was like, no. And then I had to go away and look up, what's DIP financing? Debtor in possession. So I now know. The law in Saudi Arabia provides for that, and it's I think it's a well-drafted law. Our proposal takes account of that, but I think that's an area in the kingdom where, you know, if there was one thing that I could highlight that sort of needs to be thought through a bit more and worked through, and I'm sure practice and experience will lead to that. One of the problems we found was the law provides for it. Maybe some creditors are supportive of it. But in Saudi Arabia, the SIMA, the credit ratings agency, I don't think they're going to clear our record until we exit the restructuring. Any lender in Saudi immediately prints a credit report and says you're in default, no lending. So I do think there's a bit of nuance there, and how we actually practically get access to DIP financing. And from our perspective, it's not so much paying the costs of the procedure, which I will comment on that, significantly less than I've seen in any other jurisdiction. Having done restructuring and insolvency work in other jurisdictions, it is horribly expensive. Fortunately, to date, in Saudi Arabia, it has not. I fear that as people become a little bit more alive to the opportunity, and people start hiring more lawyers and more advisors, we may end up going down that. So I would guard against that, because it's been remarkably efficient. But getting access to DIP financing to enable some of our businesses who for many years have had no access to credit. So some of our businesses are involved in the oil and gas industry, and you need performance bonds, letters of credit, guarantees, and we've not been able to get it, and we're struggling to get that now. So I think that's an area where we could see some improvement.
Thanks, Simon. Those are very, very good points.
No offense to the lawyers. I don't mean
which is all the rest in the panel, basically.
Yeah, everybody but me. Yeah.
Judge Candiora, we have a little bit of a problem. We have 12 minutes remaining, and I have many questions for you. So I hope you're okay if we do a very quick ping pong of questions. Let me begin with the first one. Do you have to deal differently with voluntary and involuntary cases, meaning cases filed by the debtor and cases filed by a creditor? How do you approach those differently, or how does the law deal with them differently? I think you're on mute, Judge. Yeah.
I'm sorry. Absolutely, a very significant difference. Briefly, a voluntary petition is filed, as Patrick said, without any real eligibility requirements other than good faith. The filing initiates the bankruptcy proceeding, off the debtor goes. An involuntary proceeding only starts a case that will lead perhaps to the equivalent of a petition being filed. So when the involuntary petition is filed, that is simply an allegation by creditors that the debtor's not paying its debts as they become due, and that this case should proceed in bankruptcy. But it doesn't proceed in bankruptcy. It proceeds on the question of whether or not the debtor should be in bankruptcy. So the involuntary petition is not at all the same as an actual petition. It is just beginning a process that could lead to a petition in bankruptcy.
Excellent. That was super clear and short. I really appreciate that. Your Honor, how many liquidations restructurings could you normally deal with in 1 year, approximately?
Oh, it depends on, you know, we always say that bankruptcy judges and bankruptcy lawyers are busy as long as there's a lot going on in the economy. If the economy's down, there will be a lot. If the economy's good, there will be a lot of need for restructuring, because there's other competitive and managerial reasons why businesses suffer some distress. Only when things are flat is there not a lot of activity sometimes. So I could have 50 or 60 cases ongoing in Chapter 11 at any given time. And, you know, those cases proceed at different paces. But yes, we can have, you know, my court may have 300 or 400 cases filed within a year. And it just depends on how active the Chapter 11 community is.
Excellent, thank you. Well, there is, you know, a general ask for advice to judges. If you had, I mean, taking into account a country where a specialization has not been the norm, or because it's a new regime, what advice could you give judges, but not limited necessarily to judges, but those working in this space, to try to create that predictability element that you emphasize that is so important?
Well, education. our system provides a good deal of education to our judges. I go to a conference, at least one conference every year. I speak at all of these many conferences. And so in doing so, I have to stay current on events. But I also go to conferences where I am educated, where I learn what's current, and I learn from experts. So education, making sure you stay on top of the law, understanding what other judges are doing and why they're doing it, so that you build that body of knowledge. I will emphasize what Patrick said, which is that early intervention with a knowledgeable bankruptcy professional is critical. It's critical for the judge to understand what's happening. It's critical for the client to understand what's happening. And so an expert like Patrick, who was hired by his client very early on the process, is as important to the process as anything else.
Thanks. And I have two more very quickly. One that was asked actually before, which is how do courts ensure that the debtor disclosure concerning assets and liabilities is accurate? Is there any work that the court does in this respect?
There's a number of reasons, a number of ways. Every bankruptcy case has assigned to it a representative of what we call the Office of the United States Trustee. This is different than a case trustee that we've talked about, a person who comes in and takes over a case or is involved in a case. The Office of the United States Trustee is an arm of the Department of Justice, and their obligation is to oversee the bankruptcy system. So a representative of the United States Trustee's office obtains all the filings. A debtor must appear and answer questions under oath in terms of all of the filings, all of the information. The debtor is probed as to whether or not anything else was disclosed. If there's any sense that everything hasn't been disclosed, there are the tools that Patrick spoke so correctly about, such as this Rule 2004 examination. It's a tool where any creditor or the United States trustee can file a request and say to the judge, we believe something is amiss. We want full access to this information or that information. And the standard for a judge to agree to that is very lenient. As long as someone states a legitimate reason, they can go forward and get the information they believe is important. Asking for documents, having people testify under oath. That tool not only applies to the debtor, but it applies to the former executives. It applies to creditors. It applies to the banks. I want all the applications this debtor's ever filed because I want to see what assets the debtor listed 3 years ago. So it's very, very broad-based. You can be very active in getting information, and these things they're very helpful. They're in fact critical. It's information leads to information, and that's what happens in the process.
Thanks, Judge. And last one for you, and then I have one for Patrick and one closing for Simon. So for you, if the complexity of the case is such that there may be a request for extension of the deadlines, is this something how is that dealt with in the United States? For example, to draw the restructuring plan? Sure.
Generally, the courts would look to see what's the need for the extension and what is the debtor doing up to the extension request. If the debtor's not been active at all and comes in and says, I need an extension and there's no legitimate reason, that's a problem. But if the debtor is trying to negotiate with its creditors, if the debtor shows some activity and some progress, then a court may likely give the extension. So what progress has the debtor made? What's the debtor doing? And what's the likelihood that an extension will result in fruition?
Excellent, Judge. Thank you so much. Patrick, in 1 minute, cross-border insolvency. This is a small topic. So the question is basically cross-border bankruptcy. We need more details. I mean, what can you say in 1 minute about the importance of Chapter 15?
I don't think that there are any. Chapter 15 is the provision where the U.S. Bankruptcy Court can open a case for a company whose original bankruptcy is actually filed somewhere else. It's a business tool. It actually plays into what Simon was talking about regarding the moratorium and the stay and getting access to information. Those are the two reasons why companies that have actually filed their bankruptcy somewhere else in Riyadh would actually seek to open a case. You're gonna have to have a jurisdictional basis to do so. But the reason you would do so is you'll get a bankruptcy court in the United States to issue. They'll recognize the case. There'll be a recognition order. And the automatic stay that we have will go into place. It's a worldwide automatic stay, which has real teeth to it in most instances. And then you'll get access to all of these discovery information tools. And that's why it's done. To my knowledge, I don't think a Saudi case has been recognized yet, but I have every reason to believe it will happen eventually, and that it will be recognized.
That was an impressive time management. Thank you so much, Patrick. Simon, there is a question about haircuts, I guess, which is basically, it mentions that I have has been successful at you know, at the expense of credit or significant discounts, which is generally the case. Restructurings are successful. But I guess the question is if other companies may succeed in getting similar treatment from the banks. Please, the word is yours again in 1 minute. Sorry.
You know, every case needs to be looked at on its own facts and merits. In our case, creditors are probably going to get 26, 27, 28 cents on the dollar. The company's giving up in excess of 90% of its assets. You can do the math. They gave up 100% in a liquidation, and then you discounted that for fire sales and everything else, the recovery would be less. Clearly, if a company can afford to pay all its debts, it shouldn't be getting such a favorable outcome. I say I know that I did a good job because everybody hates me. The creditors are not happy because they want more money, and I can promise you the people who employ me are not happy because they think they've paid too much, and you need to find that balance between the two.
Thanks, Simon. Okay, I know there are questions that keep on coming. Actually, one that was even at this very moment. I'm sorry we cannot respond to all of them in this panel, but we'll make sure to take note of them and perhaps answer them individually or in the next session that we are hopefully going to do with the Bankruptcy Commission. Dr. Abdullah, I don't know if you want to say a few closing words. From my end, I just want to thank everyone, in particular the panelists that did such a tremendous job in with so little time sometimes, but I think we've covered quite a bit of ground. Dr. Abdullah, please, the floor is yours. From my side, only to say thank you very much.
Thank you so much. I really would like to express my sincere thanks to you and to you, our trustees and experts, for attending today's. Let me switch off the audio because I can't hear correctly. Just 1 minute, please. Yeah, thank you so much for attending today. And as Andre said, we will take note of the rest questions, and we will make sure to answer them in next events. Thank you so much again for our speakers. It was great information. Thank you so much for your time, and we hope to see you again in next events. Thank you so much, and have a nice day ahead. I know some of you just started the day, and we will see you soon. Thank you so much.